Have you ever just looked at a product and known exactly what it is, even without seeing a logo? It's not magic, it's the look. You know, that specific curve, that unique shape, that visual style that just clicks. Well, today, we're going to dive deep into how that unique appearance, which is a huge business asset, by the way, is legally protected right here in India. So let's kick things off with a little question. Take a look at these two. I mean, wow, one is a piece of design history, the other basically defines modern tech. Now, besides being insanely successful, what's the one crucial legal thing that connects the classic shape of that bottle with the clean, minimalist design of this phone? And the answer is, their distinctive looks are both protected as industrial designs. Now, this has nothing to do with how they work or what brand name is slapped on them. Nope, this is all about their visual appeal, the features you see and judge just with your eyes. This kind of protection shows just how valuable and legally defensible a product's appearance really is. And how crucial are we talking? Well, it was at the absolute heart of one of the biggest corporate throwdowns in recent history. The massive, high-stakes legal war between Apple and Samsung. And trust me, this wasn't some minor disagreement. It was a full-on battle over the very soul of a product's identity, which makes it the perfect case study for us today. So here's our game plan. First, we're going to break down what a design actually is in the eyes of the law. Then, we'll walk you through the whole registration process. After that, we'll get into the awesome rights you get with the registered design. And finally, we'll dive into the juicy stuff, design piracy and disputes, to see what happens when someone copies a design. Okay, let's jump into Section 1, protecting a product's look. Before we even think about protecting a design, we need to get super clear on what the law in India actually calls a design. And believe me, it's a lot more specific than you might think. All right, let's really zoom in on the legal definition here, because every single word counts. The law says a design is defined by its features. So this could be the shape, right? Like the curves of a sports car. It could be the configuration, which is just how all the parts are arranged. It could be a pattern, like you'd see on a cool shirt, or an ornament, which is just there for decoration. But here is the absolute key, the most important part. It must appeal to and are judged solely by the eye. It is all about the look, the aesthetic, not about how it works. And to make this crystal clear, let's put what you can and can't register side by side. On the left, you've got the good stuff, the visual elements we just talked about, shape, pattern, colors. But on the right, you see what's off limits. You can't register the method of how something is made. That's probably a patent, not a design. You can't use this to protect your trademark. That's a whole other area of law. And you can't register a piece of fine art like a painting. That's covered by copyright. Getting this distinction right is absolutely crucial. Okay, so now that we know what a design is, how do you actually go about protecting it? Let's get practical. This section is all about the step-by-step journey of getting your design officially on the books in India. There are basically 4 major steps on this path. First, and you absolutely cannot skip this, you have to do a prior art search. This just means you do your homework to make sure your design is actually new and hasn't been seen or registered before. Second, you get your paperwork together and file the official application, Form 1, at the design office in Kolkata. Third, an official known as the controller will go through your application with a fine-tooth comb looking for any problems. And finally, if you pass, your design gets registered and published in the Patent Office Journal for everyone to see. Now, let's talk about the nitty-gritty. This slide lays out some of the most important forms and the fees you'll pay if you're an individual applicant. Form 1, that's your starting point, the main application to get registered, which will set you back 1,000 rupees. Down the road, you'll need Form 3 to renew your protection, and that costs 2,000 rupees. And this one's important. If you ever need to challenge someone else's design, you'll use Form 8 to file for cancellation, and that's 1,500 rupees. You know, when you file your application, your design doesn't just get tossed into a good pile. It's actually categorized using a really neat international system called the Locarno classification. Think of it like a library for designs. It organizes everything into 32 different classes based on the type of product. So for example, a cool-looking water bottle might be in one class, while a user interface icon would be in another, like class 32. This system is so important for doing those prior art searches and making sure your design is truly unique in its field. So, you've made it through the whole process and your design is officially registered. Awesome. But what does that piece of paper actually get you? What kind of legal muscle and business advantage do you have now? Let's break down the exclusive rights you're holding. First up, let's talk about time. Your initial registration protects your design for a solid 10 years. As that decade comes to a close, you get an option to renew it for one more period of 5 years. So you're looking at a grand total of up to 15 years of protection. After that, the design goes into the public domain, meaning anyone can use it. So this really gets to the core of it. Why even bother with all this? Well, the perks are huge. Registration turns your design from just an idea into a real business asset. Something with actual value. It gives you the legal power to tell competitors, nope, you can't copy my product's look. And if they do, you can sue them for damages. You can also license your design to other companies for a fee, creating a whole new way to make money. And all of this together, it builds up your brand and your reputation in the market. But that, of course, leads to the big question. What happens when somebody breaks the rules? What can you do when you find out someone is ripping off your design? And what if you see a registered design out there that you think should have never been approved in the first place? And that brings us to our final section, design piracy and disputes. This is where we'll get into what infringement really means, how you can fight back, and how you can challenge a registration you think is totally invalid. So in India, the legal term for design infringement is piracy. And the definition is super specific. It's when someone uses your design or a fraudulent or obvious imitation of it on a product. Now, two things here are really important. It has to be an obvious imitation, meaning a regular person would get them confused, and it has to be done for the purpose of sale without your permission. Making one for yourself at home might be okay, but selling it is a big no-no. And we're right back to our epic case study. This is exactly what Apple argued. They took Samsung to court, saying that a bunch of their early Galaxy phones and tablets were, in legal terms, obvious imitations of the registered designs for the iPhone and iPad. They weren't fighting about the software inside, but about the look and feel, that rectangle with the rounded corners, the bezel, the grid of icons on the screen. So after years and years of court battles that went all the way up to the Supreme Court, what happened? What was the price tag on that imitation? Samsung was ultimately ordered to pay Apple a staggering $539 million. Let that sink in. That number is a huge reminder of just how much a product's look is worth, and it's a massive warning about the serious financial hit you can take for design piracy. But what if you're on the other side, and you need to challenge a design? Well, you can't just say you don't like it. You need real legal reasons. The main ones are proving the design isn't actually new because it was already registered or published somewhere else before. You could also argue that it's just not original enough to deserve protection. Or you can show that it's one of those things that can't be registered in the first place, like a trademark or something that's purely functional. All right, let's wrap this all up with the key takeaways. Number 1, a product's look isn't just for show. It's a valuable, protectable asset called an industrial design. Number 2, registering that design in India gives you exclusive rights for up to 15 years. Number 3, getting registered is a clear, formal process. You search, you apply, and you get examined. And finally, number 4, as the Apple versus Samsung case proves, copying someone's design can be a very, very expensive mistake. And that leaves us with one final thing to think about. In a world where our gadgets are basically a part of us, how much more critical is their look and feel going to become? As tech and design get more and more intertwined, the visual appearance of a product might just become the main battlefield for who wins, who loses, and who ends up in the next big legal showdown. What do you think is going to be the next great design war?